At precisely 8:01 in the morning, a troop of stroller moms marched down my driveway like tiny Roman centurions, led by a woman in a floral visor wielding a laminated map. They stepped right over my no trespassing sign as if it were invisible, snapped a selfie on my creek bank, and announced to the children in a cheerful voice that this is a public splash feature. 10 seconds later, a sprinkler timer I had installed specifically for occasions like this hissed to life and soaked the entire group. The kids cheered and squealed with delight, thinking it was part of the fun. The woman, who happened to be our HOA Karen, declared with an indignant and outraged tone that this is an illegal river and she knows her rights. I stepped out onto my porch, coffee in hand, and said calmly, "I know my deed." The look on her face was absolutely priceless. I'm Evan Calder, part-time civil engineer, full-time quiet guy who just wanted to live in peace and enjoy my property. I bought a house at Willowbank Crossing specifically because Sage Finch Creek runs through my back acre. I loved the shade from the old willow trees, the birds that came to drink and bathe, the creek's polite gossip as it bubbled over smooth stones worn down by decades of water flow. It was absolutely perfect, everything I had been looking for after years of apartment living. Then enter Karen-in-Chief, Lynette Crowley, Willowbank HOA president for the past 4 years running, with a voice like a citrus zester and what I can only describe as a philosophy degree in other people's property. She drove a white SUV with an HOA board member bumper sticker and carried her laminated copy of the CC and RS like a sacred text. According to Lynette, anything wet, green, or remotely pleasant belonged to the community for everyone to enjoy. According to my parcel map, survey, and deed, which I had triple-checked with a real estate attorney before buying, the creek and both banks belonged entirely to me as private riparian property. The conflict was inevitable from the moment she learned about my private waterway at the Welcome Committee meeting. The campaign began with what I call cheerful tyranny. First came a glossy newsletter declaring the creek a linear park open to all residents from dawn to dusk. I received my copy in the mail like everyone else, with a little handwritten note attached that said looking forward to sharing this wonderful amenity with the community. Then freshly painted HOA wayfinding arrows appeared overnight, stenciled directly onto my flagstone path without my permission or knowledge. A Facebook post in the neighborhood group claimed the creek was a public easement by custom, which isn't even a legal concept in our state. I commented politely with a link to my property deed. She deleted my comment within minutes. Then came the actual physical trespasses that made my blood pressure rise. Lynette installed a community access gate by literally unbolting a section of my fence while I was at work. I came home to find complete strangers walking through my yard, having picnics on my grass, letting their dogs run loose near the creek. She organized creek cleanups every other Saturday that looked suspiciously like wine tastings on my favorite boulder, complete with cheese boards and portable speakers playing music. She even had the audacity to cite me through the HOA for restricting water enjoyment with hostile signage after I put up more private property signs along the fence line. The citation came with a $50 fine and a threat of daily penalties if I didn't remove the signs immediately. When I replaced the gate section she had removed, she called the sheriff, actually called 911, and cried to the dispatcher about water rights oppression and how I was denying children access to nature and violating some imaginary public trust doctrine. The deputy took one look at my deed, looked at Lynette, then looked back at me and apologized for wasting my time. But Lynette wasn't done, not even close. She posted in the neighborhood Facebook group that I was an environmental villain hoarding natural resources. She even hired a landscaper to lay decorative stepping stones in the channel without any permits, without any environmental review, without any brain cells apparently, because children deserve connectivity to natural spaces, she claimed dramatically at an HOA meeting I heard about later. Lynette finally triggered the gods of bureaucracy, and this is where things got really interesting, by ordering a contractor to dump 2 full loads of gravel into my creek to make the babbling more DA compliant, as she actually put it in an email to the board. The contractor, who clearly didn't ask any questions or check any permits, choked the flow, muddied the water, and upset a pair of western pond turtles who were in the middle of courtship. I watched from my window in absolute disbelief. That was it. I had tried being reasonable. I had tried being patient. Now I was done playing nice. I emailed Fish and Wildlife, the county floodplain administrator, and just for a little extra spice, the Army Corps of Engineers. I included photos, videos, screenshots of Lynette's emails, the contractor's truck with the HOA logo visible on the invoice, everything I could document. Within days, and I mean within 72 hours, a field biologist showed up unannounced and found crushed turtle habitat. She flagged it as unpermitted fill in waters of the United States. The Corps guy arrived the next day, lifted his sunglasses, squinted at the HOA logo on the contractor's invoice that I had provided, and said my 3 favorite words in the English language. "This is federal." I actually had to suppress a smile right there on my porch. Lynette had just upgraded her petty neighborhood drama into a federal case with federal penalties. It turned out to be a very bad week for Lynette. The sheriff, the same one she had called on me multiple times, reviewed my deed and the original subdivision plat with his supervisor. No public easement along my creek. Period. Full stop. Case closed. Code enforcement showed up next and posted a bright orange stop work order on the HOA's cute little footbridge that they had started building without any permits whatsoever. Fish and Wildlife opened a formal investigation for habitat disturbance with potential fines that could reach tens of thousands. The Corps sent a letter with so many acronyms it practically whistled when you opened the envelope. Clean Water Act Section 404, unauthorized discharge, remediation plan pending, civil penalties under consideration. Meanwhile, I wasn't sitting idle either. I sent a cease and desist letter to the HOA and filed a trespass and quiet title complaint naming Lynette individually, not just the HOA as an entity. The board's directors and officers' insurance company copied everyone on the board with a terse question that made me smile when I saw it. Please advise whether the insured acted outside the scope of her authority. Translation: they smelled smoke and wanted out of the building before it burned down completely. The other board members started distancing themselves from Lynette immediately. 2 of them resigned within days. Court looked like an HGTV reveal if HGTV specialized in consequences instead of granite countertops. My attorney, who was thoroughly enjoying himself, rolled in a foam core exhibit of the recorded plat blown up to poster size. The judge, a no-nonsense man in his 60s who had probably seen every property dispute imaginable, traced the parcel line with his pen right over Lynette's imaginary linear park designation. We played bodycam footage from the sheriff's visit where Lynette was clearly instructing the contractor to just pour enough gravel to boss the stream around, in her exact words captured on video. She had even gestured emphatically while saying it, as if directing a stage production. The fish and wildlife biologist, a patient woman who clearly dealt with this kind of environmental ignorance too often, testified about turtle nests, breeding patterns, and the fines per nest that would apply under state and federal environmental law. She brought photos of the crushed nests, the disturbed habitat, and explained in painful detail how the gravel had destroyed months of ecosystem development. The Corps representative, all business in his pressed uniform with multiple service ribbons, explained politely but very firmly that you cannot ADA a natural waterway with a dump truck full of gravel. He used words like jurisdiction and navigable waters and restoration requirements. The courtroom was completely silent except for Lynette's lawyer frantically scribbling notes and occasionally shaking his head in what looked like resignation. The judge took off his glasses, set them down deliberately, and began reading his ruling in a measured tone. He granted a permanent injunction prohibiting any HOA access to my property whatsoever. He ordered the HOA to remove every single foreign stone from the creek under direct agency supervision at their own expense. They had to restore the bank vegetation with native plants approved by Fish and Wildlife. They had to pay civil penalties to Fish and Wildlife for habitat destruction. They had to pay the Corps remediation costs. They had to pay my attorney's fees, which were substantial given the complexity of the case. They had to pay me damages for loss of quiet enjoyment of my property. The total for the HOA was somewhere north of $65,000. Then he turned to Lynette personally, and this is the moment I had been waiting for through months of trespassing and harassment. Personal liability for willful trespass, destruction of property, and false representation of public rights. A 2-year ban on serving on any HOA board in the entire county. Personal fines totaling $25,000. The total amount between the HOA penalties and her personal liability came to over $90,000. Lynette started crying right there in the courtroom, her face turning red and blotchy as the reality sank in. She tried to speak, tried to say something in her defense, but only managed a choked sob. Her lawyer put a hand on her arm to quiet her. I sat there in my seat with the smallest smile on my face, watching karma deliver its invoice with interest and late fees included. Somewhere outside the courthouse, a turtle blinked slowly, like nature's version of a slow clap.